had significant experience representing people accused of weapons charges in both San Francisco and all of Alameda County, including Oakland. I was a public defender in Alameda County for 6.5 years, where I handled thousands of cases involving several different kinds of weapons, mostly firearms. Firearms in both counties are by far the most common weapons charge that are seen for a few different reasons. One of which is that, a lot of weapons, if police find them, police don't always book the individual for it. For example, pocket knives, maybe something like brass knuckles. The officer who finds it might not feel like writing a police report about it, might not be so personally offended that they think they need to arrest the person for it. But occasionally that happens, those charges come to court. More often than not, they're charged as misdemeanors, where the maximum punishment is 1 year in county jail. Firearms are far more likely to be charged than other types of weapons, just simply for the fact that the police who enforce the laws have an active personal interest in getting firearms off the street more than they do with any other type of weapon. In Alameda County, the standard settlement offer for a gun possession, whether it's a misdemeanor or a felony, is at least 120 days. That's not to say that everyone charged with the crime should expect a 120-day offer. That is to say, it will always be at least 120 days. And depending on what aggravating circumstances might exist, such as the person's criminal history, whether they have a prior felony conviction, whether they actually use the firearm in some way other than simply possessing it, those are all aggravating circumstances that will add more time onto that minimum offer of 120 days. That's not to say that the smallest sentence the individual will get is 120 days. That's just the least that the district attorney is willing to come to an agreement to settle the case for. It is possible to negotiate a better deal with the judge himself. There are occasions where you can actually almost take the district attorney out of the equation if the judge does not think the district attorney's offer is reasonable. The judge can give their own offer, which is less. The only caveat is, in order to take a judge's offer, you have to plead to everything with which you are charged. Whereas if you negotiate something with the district attorney can agree to drop certain charges in exchange for you pleading guilty or no contest to another one. And the calculation, the decision as to whether you should go with the judge or the district attorney is obviously based on how much time the judge is offering to give the person if they take the judge's settlement offer. But also, what are the other charges to which they're pleading? For example, if there's a gun charge, if there's a gun charge and a sex charge, and the sex charge would require mandatory lifetime registration as a sex offender, and the district attorney is willing to dismiss that if the defendant pleads guilty to the gun charge for, say, 3 years in prison, and the judge thinks that's a ridiculous offer, he'll offer the person probation for 6 months in county jail, but they have to plead to everything. Well, then the defendant has to consider, do they really want to register as a sex offender for their entire life just in order to get a smaller sentence? I think probably not. I know I certainly would not if I was in that position. God willing, I never am. But ultimately, if you're in that situation and the district attorney is willing to dismiss that sex charge, then it probably means they can't prove it at trial. So in that case, why take the judge's offer if you're more likely to beat the sex charge and then get less time after trial? So I'd probably advise my client to just take the case to trial in that circumstance. In San Francisco, there's really no minimum sentence. There's really no minimum plea deal. But they're just as aggressive about prosecuting gun possession, and they do take it seriously. So even though there's no minimum, it's still quite likely that the offer is going to be something around at least 120 days, 4 months, quite often more time than that. San Francisco tends to be much more reasonable in the way the district attorneys approach settlement offers. The settlement offers often tend to be more tailored to the individual issues plaguing the defendant's life. San Francisco approaches criminal case settlement in a way that addresses the issues underlying the problems that led the individual into crime in the first place. That doesn't always happen. It's just much more common in San Francisco. So that's really the main distinction between settling cases in San Francisco versus Alameda County.